everyone, welcome to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Illegal fishing in Indonesia and the role of international maritime law on illegal fishing action. The United Nations Conference on the Law of the Sea held the United Nations Conference on UN Clause 3 that end with the endorsement of the final manuscript in Jamaica dated December 10, 1982 by 118 states and covers matters including codify the provisions of existing maritime law such as freedoms on the high seas and the right of peaceful passage in the territorial sea, development of existing maritime law such as the provision of territorial sea wide to a maximum of 12 nautical miles and the criteria for continental shelf, and creation of new rules such as island nation states, exclusive economic zone, and international seabed mining. The maritime boundaries set out in the UN clause in 1982 include the boundaries of the territorial sea, the limits of the exclusive economic zone, and the limits of the continental shelf. The clarity of the boundaries of the waters of a state provides benefit to state itself, which is to help clarify the defense of the state, in example, to safeguard the possibility of attacks or infiltrations from outside the territory. For a country following UN Clause 1982, dividing the sea into three types or maritime zone. First, the sea that is part of the territory of sovereignty in the territorial sea and inland sea. Second, the sea is not a sovereign territory, but it has the right of jurisdiction over certain activities or in additional zones and exclusive economic zones. And the last, the sea is beyond two above or not including its sovereign territory and not jurisdictional territory, but the country has an interest or such as free oceans. UN clause also regulates the rights and obligations of coastal states to which the state in respect of the state may apply to the coastal state, may uphold its laws and regulations as set forth in the Convention on the Law of the International Sea, UN Clause 3, in Article 73, which states that the coastal state may, in exercising its sovereign right to undertake the exploration, exploitation, conservation and management of living resources in the exclusive economic zone, to take such measures, including boarding, examining, apprehending, and conducting judicial proceedings as necessary to ensure compliance with laws and regulations stipulation in accordance with the provisions of these conventions. The captured ships and their crew shall be released immediately after being given a proper security deposit or other form of security. The coastal state penalty imposed on violation of the fisheries legislation in the exclusive economic zone shall not include confinement if there is no contrary agreement between the state concerned or any other form of corporal punishment. The archipelagic countries that have strategic position and have great potential fishery resources attract the attention of foreign fishing vessels to illegal fishing. In addition, one of the factors of the occurrence of illegal fishing is the need of world fish or demand increases. On the other hand, the world supply of fish decreases and there is excess demand or over demand, especially types of the fish from the sea such as tuna. Associated with the problem of illegal fishing, the effort of a state that suffered losses is also a thing to be recognized with. Efforts taken by a state in handling cases of illegal fishing must be regulated in a clear regulation. In fact, the efforts taken by a state with a different state, as an example of Indonesia, the effort taken by the Indonesian government is the sinking of foreign fishing vessels by means of blasting. Illegal fishing action is not only detrimental to the economy with the value of trillions of rupees lost, but also destroy the fisherman economy. It also poses a political impact on the relationship between coexisting states, violates the sovereignty to the state, and threats to the conservation of marine biological resources. As described above, in Indonesia, there has been the arrest of foreign fishing vessels that do illegal fishing accompanied by the action of sinking the ship by blasting. The goal is to provide a deterrent effect and demonstrate the firmness of the government in realizing sustainable and responsible fisheries. However, it should be remembered that the act of drowning However, it should be remembered that the act of drowning by means of the blasting of ships belonging to other states may also violate the provisions of the Charter of the United Nations, which bind Indonesia as a member. Therefore, this study aims to analyze on how far the government's role and action in its handling the case of illegal fishing in Indonesia, what is the impact of government policy in handling cases of illegal fishing in Indonesia, and extent to which the role of the international sea law in handling cases of illegal fishing in Indonesia. According to priorly international laws, as a set of rules of principle for do something that binds the civilized nation in their relationship with others. And according to Charles Cheney, high international law is a set of laws consisting largely of principle and regulation that must be obeyed by countries. Therefore, international law must be adhered to in relationship with one another. In the beginning, international law only regulates relations between nation and state as a legal subject. However, it develops the subject of the laws, such as international organization and the national liberation movement. In certain cases, international law is suspect of being imposed on individuals in relation to countries. The sea can be used by mankind as a natural resource for its livelihood, shipping lanes, defense and security interests, and other interests. The function of the sea above have been felt by humanity and have given impetus to the mastery and exploitation of the sea by each country or kingdom based on a conception of international law. The birth of the concept of international sea law cannot be separated from the history of the growth of the international maritime law that recognizes the difference between two conceptions, namely, first, res communis, which states that the sea belongs to the people of the world and therefore cannot be taken or owned by each country, and the second, res nullius, which states that no sea has possession and therefore can be taken and owned by each country. In the context of the state's sovereignty over the sea, the growth and development of international maritime law after the collapse of the Roman Empire began with demands of a number of states or kingdoms over a part of the sea bordering its shores for various reasons. For example, Venetia claims most of Adriatic Sea, a claim recognized by Pope Alexander III in 1177. Based on his authority over the Adriatic Sea, Venetia collects duties on every ship that sails there. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one, bye bye.